and help us to resist oppressors' rule with all our will and might forevermore. Can we give ourselves a round of applause for singing our national anthem beautifully? So, Reverend, I believe it's time for us to ballot now. And we have captains from each of the schools or each of the teams. I'll hand over to Reverend Ankrabano to take us through the ballot.
These are the faculties that are ready to battle in the maiden edition. And I want to assure you, there's a law firm that has really given us their word that at the end of the day, all those of you who are participating, when you have internship or you want to do vacation something, they are ready to offer you a place for you to do your internship there. Yeah.
Welcome to the Law Challenge 2019. This is the maiden edition. The Law Challenge simply is pursuing a mission of spreading the fragrance of the law to everyone, not only to the contestants who are here today and not to the people in the audience, but also to you at home. Welcome to this educative, liberating, and empowering project on your television, the Law Challenge. To our contestants, the maiden edition is hosting 6 universities and university colleges with law faculties in Ghana. And they will go through various rounds, from rounds 1 to 4. And at the end of each competition, the best will be chosen to continue in the competition in the next round. Let's begin by having the contestants from the various university and university colleges introduce themselves. Let's begin with the University of Cape Coast.
Nicholas Nantechi, University of Cape Coast.
Benedict Hamamesa.
James Otu, University of Cape Coast.
Shall we hear from King's University College?
Seth Glechu.
Jeremy Ado Apia, King's University College.
Campbell Della Aivo, King's University College.
A round of applause for them. Let's begin with the first round. The first question is to the University of Cape Coast. What do you understand by the term lifting the veil of incorporation? Yes,
Lifting
James.
the veil of incorporation occurs when the company being a separate legal entity and the actors or organs of the government have organs of the company have committed an error, or they have done something which is authorized their powers, or they have done something that is in their best interest, the veil will be lifted to assign an abuse to individual members who have done that, committed that act.
Is that your final answer? Yes, you still have some time.
Yes, it's a principle that protects people who are involved in a company. That is the directors and members, shareholders of a company. This is done because a company is supposed to be a separate legal entity, distinct and on its own from the members involved. So this principle ensures that liabilities are not directed to the members who form the company.
So when it is lifted, then the civil and criminal liability can assign to the individual who have committed that offense.
All right, you've been bailed out, and I think that you are deserving of 8 of the full marks. I won't be able to pass this question on because they have been able to answer the question in the larger sense. And it is that when the law ignores the separate legal status of a corporation and ascribe liability, that is penal or civil, to various individuals like the members or directors of the company. So, in a large part, James, you are right. Now, let's go to the King's University College. And your substantive question is, who may lift the veil of incorporation?
The court. The court has a right to lift the veil of incorporation when a case is brought before it. Either the court can, on its own, call for the veil to be lifted when a member has acted otherwise, or the registrar can also call for it to be lifted, or members can bring action for the court to in fact, lift the veil for liability to be imputed.
Once again, are you done? There is time. Okay, you've been bailed out. Once again, you should be deserving of 8 points in that marks. Because you could have exhausted how the veil can be, who may lift the veil, and not limit it only to the courts. Beyond the courts, legislation, the company's code. Thank you very much. Proceeding from there, we're back to the University of Cape Coast. Through whom may a corporation or company act? James.
To the registrar. The promoters will form the company and they will submit the company's regulation to the registrar. If they're able to meet the criteria in section 16 of the Companies Act 1963 at 179, when all those conditions have been satisfied, then the registrar will issue certificates of incorporation to the company.
Yes, Benedicta.
The company may act through the directors who control the affairs of the company.
It's correct, but that does not attract the maximum marks. Through whom may a corporation or company act? You've given a part of the answer, not the full of the answer. Because a company may act through its members in general meetings, its officers or agents appointed under the authority derived from members in a general meeting again, or the board of directors or officers or agents appointed by or under authority derived from the board of directors. And you stuck to one way by which a company may act. But that is deserving of 8 marks. Thank you very much. Now to the King's University College. What is the rule in force and habital? What is the rule in force and habital?
The rule in force and habital says that no individual member can bring an action against another member to a court without going through an AGM. or any company resolutions.
Yes, please go on. You have time. If any of your members want to contribute any further, you are allowed.
So it speaks to the fact that no individual member is supposed to bring liability. Now, except there's been a resolution passed by court, through an AGM, or where an individual seeks for redress by a court.
That certainly is not a complete response, but it is deserving of the full marks, 10 marks. A round of applause for them. The essence is that the rule is as defined to represent the limitation on the members or minority rights to sue to compel a company to conform to its regulations or to enforce a claim belonging to the company. And that will be your second question. So let's go to the University of Cape Coast. And University of Cape Coast, this is your third question, crying for 10 marks. And the question is, what is a dividend?
A dividend is the amount that is being distributed to the shareholders after the company has paid all the necessary expenses, and the amount that will left. Then the board of directors at annual general meeting would pass resolution whether they should pay to the directors or not. So the dividend is the interest, or in other way, the benefits that the company shareholders will get from investing their money in the company.
Correct for the 10 points, please. So you had the question answered correct even at the start, and in the middle you also answered it correctly. All we needed to identify is that you were talking about the benefits to the shareholders for their contribution of capital to the company. That is dividend that every company ought to declare for its members or its directors, shareholders, to benefit from. Thank you very much, University of Cape Coast. You get the full marks for that. From the question of what constitutes a dividend, King's University College, is there any difference between assault and battery? If yes, what is the difference? And if no, what are they? Why?
Basically, assault requires no contact, but it is a conduct which leads the plaintiff to apprehend the application of force. Most of the times, assault is always preceded by battery, and also words and gestures are also sufficient to amount to an assault, indicating that there is a slight difference between assault and battery. Battery has to do with the intentional touching of or application of force on the body of another person, with or without the person's consent. So, with regards to this difference, with regards to the...
That is a most exhaustive answer. And it gains you, of course, the full marks. King's University College. It is now the turn of the University of Cape Coast. To succeed on a claim of malicious prosecution, a plaintiff need to prove... What does a plaintiff need to prove to succeed on malicious prosecution?
One, the defendant might have insisted action against the plaintiff. Then the action must have been terminated in favor of the plaintiff. The defendant insisted action in malice. The plaintiff must also prove that he has suffered a damage.
That is another comprehensive response. University of Cape Coast. That certainly earns you the full marks. Right. Shall we turn now to the King's University College, and this will be your fourth question. And the question is this. A's land is adjacent to B's land. There was a big dead mahogany tree standing on A's land, close to his boundary with B's land. During a heavy rainstorm, the tree was blown down by the wind. It fell on B's land and destroyed some of his crops. B has sued A and is claiming damages for trespass for allowing a tree on his land to fall, destroying his crops. Can B succeed?
So before we go straight to the answer, there's a rule in Ryder and Fletcher where it was decided by Blackburn J that in view of these instances, there are some things that need to be proved by the claimant. One, that the defendant brought something onto his land, that he made a non-natural use of that land, and that the thing was something likely to cause damage if it should escape, and the thing did escape and cause damage. So since the mahogany tree is a non-natural use of that land, and it was caused by a rainfall leading to B's land, should B be able to exhaust all these remedies stated by Blackburn J, then the B will be successful in the suit against A.
Correct. Correct on the basis that you began with the answer. Will he succeed? And your answer is that he will succeed under the rule in Raylands and Fletcher. Truth is that he will not succeed under trespass. So I believe that you have sufficiently answered the question to have identified the ingredient to merit a 8 out of 10 of the marks. To the University of Cape Coast, what is the difference between slander and libel? Yes, Nicholas.
Basically, both come together to form defamation. And with slander, we are looking at words that have been spoken by a defendant that defames or impugns the reputation of a claimant. But with the libel, we are looking at things that have been written or things that are more permanent that defames or impugns the reputation of the defendant.
Absolutely. For all the 10 marks, the answer is correct. The difference is clear. One is spoken, and the next is written in defamation. King's University College, you get the very final question in this round. And your question is, under customary law, there is only one defamation action, and that is the action of slander. Is this true? If it is true, what is the difference between customary law slander and common law slander?
Okay. So since slander has to do with spoken defamation, and examples of slander can be gesticulation, mimicry, or a sign language from a deaf and dumb person. That is under the common law.
Okay. I'm sorry, but that answer cannot qualify for any of the marks. I will pass it on as a bonus to the University of Cape Coast. Yes, Nicholas.
Yes, under customary law recognizes slander because back then we were not writing as a people. So most of our defamatory issues had to do with oral issues. So under customary law, it was about the words that were spoken, but which includes imputation of unchastity, imputing a venereal disease, and then when you talk about someone's profession, so That is the difference. That custom.
It's a bonus. It's a question that was passed to you for a bonus mark, and you can earn 2 out of 5 of the bonus mark. You were right in answering that yes. Under customary law, there is only one defamation action, and that is slander. And you gave an explanation for that. But you were asked to give the difference between customary law slander and common law slander. And there you fell short. Yes, it is true that under customary law, the only action in defamation is slander. The difference between customary law slander and common law slander is that while customary law slander is actionable per se, you learned this in your class, common law slander is actionable on proof of special damages. On that note, a round of applause again for our contestants. This will be the end of the first round, and I must say that our contestants have done very well. The law challenge. The law challenge. At the end of the first round, University of Cape Coast made 48 marks. The King's University College made 36 marks. Congratulations to both of you, and we move straight to the second round. You call it the buzzer round or the round where I will be asking, who am I? Then you are going to be looking at questions from criminal law, contract, tort, company, and the Ghana legal system. Unlike the first round where you had 5 questions, you will have 6 questions in this round. If you are the first to press the buzzer, I will call upon you to give me the answer. Now, you do that in 30 seconds and for 10 marks. If you give me the wrong answer, you lose 5 marks. If a team presses the buzzer before the question is over, I will simply pause and ask you to take over the wheels. Are we clear? On this note, a round of applause again to our contestants. The law challenge. Legally speaking. The question is, I am one of the maxims of equity. Perhaps I am the most important of all. I provide the primary justification for the intervention of equity. My intervention is to ensure that all justiciable wrongs.
Equity will not suffer a wrong to be without a remedy.
And that is correct for the full marks. To my next question. Who am I? I apply often to contracts. By me, equity treats a contract to do a thing as if the thing were already done. My application is subject to caution. I am subject to all the frailties of all equitable interest. I apply only if the contract is one which is capable of being specifically performed. By me, a person who enters into possession of land under a specifically enforceable agreement for a lease is regarded as being practically in the same position as if the lessee had actually, as if the lease had actually been granted to him. Yes, so time is running. Okay, time out. Ladies and gentlemen, I invite you to be bolder the next time. What would have been your answer? He says his answer would have been specific performance. How about you?
Equitable interest.
Equitable interest. Equity certainly looks on that as done which ought to be done. So, to our third question. I'm normally accompanied by restitution. I am a remedy by which one party to a transaction may set aside that transaction. University of Cape Coast. Rescission. That is correct for the maximum point. I am an agreement between parties who have capacity for a price measured in terms of money, effort, forbearance, or exchange of promise. University of Cape Coast again, Benedicta.
Consideration.
Wrong, not correct. So, the King's University College, you have the opportunity, but let me continue and then you tell me if you know the answer. So, I said, I am an agreement between parties who have capacity for a price measured in terms of money. Yes.
Contract.
Contract. That's correct for 10 points. Okay. Fifth question. Yes. I am a special type of mistake. I am a mistake over documents. One may rely on me to claim that a document bearing his name or her signature is in fact not one's document. University of Cape Coast. Benedicta.
Non ex factum.
Non ex factum. Correct for the full points. So may I complete who I really am? That I protect particularly the blind and the illiterates. To plead me successfully, there must have been a mistake. The one who made the mistake was misled into making it. The mistake relates to a document radically different from what one thought he or she was signing. The one seeking to rely on me should not have been guilty of carelessness or negligence. I must specifically be pleaded and particulars proved. Thank you very much, University of Cape Coast, for that wonderful performance there. Shall we now go to the very last question in this round of who I am? I am a common law defense available to a contracting party to nullify the consent and thereby nullify the contract where there has been coercion of will. University of Cape Coast.
Duress.
Duress, and that is correct. So I complete the puzzle. I am a common law defense available to a contracting party to nullify the consent and thereby nullify the contract where there has been coercion of will. To succeed in a plea of me, the party relying on it must establish actual or threatened physical violence to or unlawful constraint of the person of the contracting party, which will suffice for the purpose. The present position is that to be capable of giving rise to me, the threat must be illegitimate, either because what is threatened is a legal wrong, or because the threat itself is wrong, or because it is contrary to policy. This is where we come to the end of the second round. A round of applause to the contestants once again.
Here's innovation from Goyle that takes you further. New Goyle Gold Super Synthetic 5W20 and 5W30 lubes have been expertly crafted with the latest in liquid engineering technology, highly advanced for modern engines, prolongs oil change intervals, save you fuel, clean, protect and enhance engine performance. The way engines work has become complex, and Goyle has innovated to stay ahead with expertly crafted lubricants that work excellently with all petrol and diesel engines of today. New Goyle Super Synthetic 5W20 and 5W30 lubes. Innovation that takes you further. Goyle. Good energy.
You're welcome back, and this is the Law Challenge 2019. The Law Challenge. Legally speaking. Thank you very much, and a round of applause once again for our very smart and intelligent contestants. Now, at the end of the second round, University of Cape Coast scored 25 marks. The King's University College also scored 20 marks. Putting rounds 1 and 2 together, King's College has been able to bag 56 marks, whilst the University of Cape Coast has 73 points. A round of applause for all of them once again. Now, welcome to the rules for the third round. And in this third round, we will be identifying some quotations, and so you can call it the quotes and identification round. Each team will be giving 3 quotations and will be asked to identify the personality the quote is attributed to. And then you don't stop there. You tell us in which case the quotation is found. You have 20 seconds to answer the question. If you answer correctly, you gain 15 marks. There will be no negative marking for incorrect responses. Each team will also be given an opportunity to identify one personality within the law fraternity. And this is a non-transferable round. Who made this statement and in which case? And listen carefully. Quote, a perusal of Exhibit AG 16 and AG 17 already referred to supra indicates quite clearly that the second and third defendants, after their initial disagreements about their entitlements, later entered into an alliance to create, loot, and share the resources of this country, as if a brigade had been set up for an enterprise. And the question is to the University of Cape Coast. Don't disappoint me. This is a very popular quotation.
Bamford Addo, in the case of...
Okay, the time is up, but it is not Bamford Addo. Justice Bamford Addo had ceased to be a judge, even at the time when this statement was made. This quotation belongs to Justice Jones Doche, and in the case of Martin Alamisi Amedu versus the Attorney General, Waterville Holdings, BVI Limited, and Alfred Agbeshi Woyome. Shall we turn to the King's University College. Tell us who made this statement. A written constitution, such as ours, is not an ordinary act of parliament. It embodies the will of the people, of a people. It also mirrors their history. Account, therefore, needs to be taken of it as a landmark in a people's search for progress. It contains within it their aspirations and their hopes for a better and fuller life. The Constitution has its letter of the law. Equally, the Constitution has its spirit. This statement is attributed to who and in which case? I'm waiting for your answer.
Quao and Attorney General. Quao, Attorney General. Justice Banfo.
Justice Banfo. That is wrong. It's incorrect. Once again, this is yet another very famous, popular legal scripture. And I can see that the University of Cape Coast, Benedicta, was getting ready for that answer. Okay, so that statement is Justice Soa in the case of Tufo and Attorney General. So you see that you knew the answer. Take your time and produce the answer. So let's go to the University of Cape Coast. It is your turn. Remember, only 3 questions. So this is your second question. And here is the quotation. Yet, this court is being invited to prevent the government from spending monies which Parliament has constitutionally provided for government use. I think if the order is granted, it would amount to judicial officiousness, poking our noses into the affairs of Parliament and intermeddling with the prerogative of the executive by directing the government not to spend monies approved by Parliament. Such a move clearly amounts to a violation of the doctrine of separation of powers, which is the core of our Constitution, 1992. Yes, University of Cape Coast. Who made this statement and in which case?
NPV,
Yes, James.
NPV versus Attorney General, 31st December case.
You got the case correct, but you've been bailed out and not the judge. So you get 7.5 instead of the full 15 marks for this question. That was in the 31st December case. New Patriotic Party versus Attorney General, 93-94. Ghana Law Report. Shall we now have King's University tell us who is speaking and in which case? This contention seems to be highly artificial, and I cannot believe that with the known pragmatism that informed judicial attitude towards questions of legislative interpretation, the Attorney General has thought an argument as this was likely to carry seasoned judicial minds. We should fail in our duty to effectuate the will of the Constituent Assembly if we interpreted the Constitution not in accordance with its letter and spirit, but in accordance with some doctrinaire juristic theory.
Aqua JSC in Amido and Attorney General.
Unfortunately, that is incorrect. It's one of the popular quotations attributed to Apollo J.A., as he then was in the case of Salah versus... Good. Your very final question, University of Cape Coast. Here is the statement. The scope and extent of the doctrine of separation of powers, in my respectful view, and as I understand it under the Constitution 1992, is to ensure that each arm of state, in the performance of its duties within the framework of the Constitution 1992, is to act independently and should not be obstructed in the exercise of its legitimate duties or be unduly interfered with by the Constitution. In other words, all arms of the state are answerable or responsible to the Constitution 1992. Who is speaking and in which case?
Ghana Bar Association versus the Attorney General. Read to JSC.
Thank you very much. His Lordship Edward Redu in the celebrated case of Ghana Bar Association versus Attorney General. King's University College, it's your question. And this is your last question too. I am requiring you to identify their case, not the judge making the statement. So, here is the statement. The National Liberation Council, being sovereign, could do everything except turn a man into a woman or vice versa. In which case, do legal scholars, students of the law, find this celebrated, famous, infamous statement?
MPP versus Attorney General.
National Liberation.
That's incorrect. Unfortunately, you have been bailed out, King's University College, and the answer is Shalaby versus Attorney General. You just remembered? Oh, gee. But, of course, it does happen that you remember only after it's been pointed out. Ladies and gentlemen, still in round 3. And this is a time where we get to know how familiar you are with the lords, the justices, the law lords in this country of ours. So, you have 20 seconds to identify who you see on that screen. So, I start with the University of Cape Coast. "20 seconds. Who is that?
His Lordship, Justice Archer.
I'm sorry, that is incorrect. And it's not a transferable question. You are too ready to answer that. It is Justice Enin Yeboah. King's University College. Look on the screen and tell me, who is that?
Justice.
Yes, Campbell.
Justice Jones Doche.
Justice?
Jones Doche.
That is correct. I asked you to repeat the answer because I heard Jones Doche instead of Jones Doche. Okay. Now to the University of Cape Coast. University of Cape Coast. Whose image is that?
Owusu JSC.
Sorry?
Owusu JSC.
Owusu?
JSC.
JSC. I'm sorry, unfortunately, University of Cape Coast, that was Justice Julius Ansah. King's University College. Whose image is that?
Justice N.S. Bidigwe.
That is correct. All right. On that note, we bring the third round to a close. We'll be right back.
Ever pure, purified drinking water. Always pure, ever refreshing.
You're welcome back to the Law Challenge 2019, and this is the maiden edition, the Law Challenge.
Legally speaking.
And congratulations again to both sides, University of Cape Coast and the King's University College. I must say that I am proud of all of you because some of the quotations, they are difficult to identify. But I invite you to now visit the courts as regularly as you can so that you don't miss the images that you missed earlier. Now, at the end of the third round, the results stand at King's College University, 30 points. University of Cape Coast, 22.5 points. All the rounds put together from third, second to the third, King's College has 86 points. And the University of Cape Coast has 95.5 points. So, ladies and gentlemen, get ready for the very final round of this competition. First, the rules. And as you know, the fourth round is what is known as the rapid fire round. And in this round, you are supposed to nominate one of you to be the one to take the questions, to answer true or false as rapidly as possible, 10 questions within 90 seconds. If you get a question correct, you get 5 marks for your team. And whilst your time has not run out, if you skipped or were unable to answer any question earlier, you have the opportunity to now answer that question. You have a team leader each, and that team leader will respond to the questions in this session known as the rapid fire round. You are answering true or false to a statement that I will make. And you shall have 120 seconds within which to answer 10 questions. You get 5 marks for each correct answer you gave. But if you were unable to answer a particular question, you are at liberty to answer it when your time still runs and not exhausted. I will begin this round with the King's University College. A suspect or an accused person who has been granted bail by a court of competent jurisdiction is supposed to pay money before being
False.
released. Thank you, false. False and habitual. is also referred to as the principle of majority rule. True or false?
True.
Correct. Article 19.5 of the 1992 Constitution states that a person shall not be charged with or held to be guilty of a criminal offense unless the offense is defined and the penalty for it is prescribed in a written law. True or false? True. You are right. Article 19.11, still staying with Article 19 of the 1992 Constitution, provides that no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it is prescribed in a written law. True. That is true. Under our Criminal Offences Act of Ghana, 1960, Act 29, as amended by Act 554, Section 4, an infant is incapable of committing a criminal offense. True or false? True. That's true. The mischief rule is also known as the rule in the Hayden's case. True or false? That is true. And Article 267(5) of the 1992 Constitution prohibits grants of freehold interest in stool lands. True or false? True. The literal rule is also known as Sussex peerage case. True or false? True. That is true. Article 2661 states that no interest in or right over any land in Ghana shall be created which vests in a person who is not a citizen of Ghana, a freehold interest in any land in Ghana. True or false? You say true. That is correct. A very final one. A lease for life, that is a life tenancy, cannot be expressly created in Ghana. True or false? True. And that was true. And on that very brilliant note by Jeremy Appiah-Addo of the King's University College, can I expect a repeat from the University of Cape Coast? And who is your leader? Nicholas Nyantechi. Marimba injunction and Anton Pillar orders are special forms of interlocutory and ex parte injunctions. True or false?
Skip.
True or false?
Skip.
Article 2663 stipulates a specific date in which a person who is not a citizen of Ghana, having a freehold interest or right over any land in Ghana, such interest in or right shall be deemed to be a leasehold for a period of 50 years at a peppercorn rent. True or false?
True.
Great. And Article 2712 of the 1992 Constitution states that the House of Chiefs of each region shall elect as members of the National House of Chiefs 5 paramount chiefs from the region. True or false?
False.
Incorrect. A lease is still valid as a lease if the landlord maintains a concurrent control on the land. True or false?
Please repeat.
A lease is still valid as a lease if the landlord maintains a concurrent control on the land. True or false?
True.
That's false. At common law, a lease automatically terminates at the end of the lease period. True or false?
Please repeat it.
At common law, a lease automatically terminates at the end of the lease period. True or false? True. That's correct. Since 7th January 1993, all lands, including stool lands, may be vested in the state. True or false?
False.
Correct. False. Bird versus Jones is a case that deals with false imprisonment. True or false?
It's true.
Correct. The statute that regulates sale of goods transactions in Ghana is the Sale of Goods Act 1962, Act 137. True or false? That is correct. The provisions of the Sale of Goods Act. The provisions of the Sale of Goods Act 1962, Act 173, Act 137 apply to the sale of shares in a company. True or false? False. That's correct. It's false. So that was a wonderful performance by the University of Cape Coast as well. Right, so at the end of round 4, These are the results. But first of all, let's give a round of applause for both teams, University of Cape Coast and the University, King's College University. At the final round, round 4, King's College, 50 points. UCC, 30 points. All the rounds put together, King's College have managed 136 points. And the University of Cape Coast have also managed a total of 125.5 points. At the end of the contest, King's University College, with 136 points, has emerged the winner of the preliminary stage of the contest between them and the University of Cape Coast Faculty of Law. The Law Challenge is brought to you by the kind sponsorship of WebSys Technology, the Web Guys. Ever pure, always ever pure, refreshing. Notes, Logistic Movers, we help you relocate. Goyle, Good Energy, Agate Enterprise and Transport Services, official transport provider. Busy, great things happen. EPP Book Services, discover the world of books. Media General and Alisa Hotels. Thank you for your company.